Good evening, everyone. Welcome. I'm Rudolph D'Souza, your host on today's webinar by MyNation Hope Foundation. Thank you for being with us today. We appreciate joining us on every Sunday on different topics and Men Ki Baat. Today, we are discussing uh, about how men are harassed uh, by our legal system. Many are acquitted after struggling for many years, fighting for many years, but even it's false case filed on them, but our legal system is not taking any action on those who misuse our laws. I welcome Sagar Mohanty today in our webinar, Men Ki Baat. We'll discuss his case and he will tell you how he come out here or won his case, even it was false. Welcome, Sagar Mohanty. Please introduce yourself.
Uh, yeah, hello everyone. Hi, Rodi sir. My name is Sagar Mohanty. So I'm from Odisha. I stay in Hyderabad from past 8 years, and I didn't have any criminal cases till now. And used to be a scholar student, but after marriage of 3 years, I got false cases like 498A and other cases. So I'm a victim of
Okay,
women-centric bias law now.
okay. Who filed case on you?
My life partner, who promised to be with
Okay,
me till the death, and she filed 498A, 506,
okay,
406, 323, and
okay.
3 and 4 DP Acts. And if I say last
Any
year
other?
on this day only, yes, sir, last year this day
Okay,
only she filed, and today is the anniversary I'm celebrating for 498A.
good, good. Congrats, congrats. Okay. Any other family members are included in your case?
Me and my parents only, who had never
Okay.
resided with me. My parents used to stay in Odisha. They never came to Hyderabad, and still they are in the FIR.
It was arranged marriage or you found her?
We can say like it's a yeah, it's like I got a Facebook request, and from there I had some mutual friends. From there I came to
Mhm.
know, and it
Okay.
went
Okay.
for
So you
arranged marriage.
you
So
knew her before.
I never knew. Through my mutual friends only, I came to know about her from Facebook, and later my parents
Okay.
went and her parents they both discussed, and the marriage happened.
Okay. How long you have been staying together?
We stayed together Feb 2017. We got married, and we are staying
Mhm.
together till October 2019. So it's been 2 years and 8 months.
Okay. So what was the reason she filed the case on you?
Actually, mostly in this new era, women wants to dominate their husband or their in-laws. They don't follow the customs that our mother or our grandmothers are following. So whenever we used to say like, why you are not following, so they started
Mhm.
harassing us, and they underestimate me, and lots of temperament happened, and finally it
Okay.
end with ego. So it was mostly ego based, and they filed this 498 to
Mhm.
fix me and my parents.
Okay. Okay. She filed in police station or court?
She filed in police station only because her mother works in police department in Odisha, so they had a very good
Okay.
contact.
Was there any proper inquiry?
No, nothing happened. So police did not do counseling. So and there is no 41 and notice, and the complaint filed on the same day, that is on Friday. So the FIR happened after
Mm-hmm.
2 hours of complaint. And later, in 1 hour, I got arrested. So from my office premises,
Mm-hmm.
and they said like they will be
Okay.
doing some counseling, but they did not do any counseling, and it was a long vacation of the Shera. So I was remanded, and I
Okay.
was in judicial custody for 5 days.
Okay. Even there is a Supreme Court direction not to arrest. they arrested you without serving any 41A notice, right?
Yes, correct.
Okay, that's how police are harassing and misusing law. They're supposed to be protector of law, but they are the first one to misuse. Anyway, here we have one more example, live example, where police, without serving 41A CRPC notice or without doing any proper inquiry, they arrested. Anyway, what is the outcome of 490?
Later, after 2 months of 498A, my wife
She
withdrawn it. Yes,
okay,
without
withdraw.
any
Why
reason,
she was not
she
having
withdrawn. Yeah,
any
she
she
did not
was not
had
having
any.
any evidence or proof.
Yeah, without any evidence, like zero evidence and zero witness, she filed the case and it was done. But later, when I
Because
provided
it
all the
was
evidences to
false.
the police, yeah.
Yeah, that's what. It
So
was a
when I given
false case. How
the
can I say? Because many women are bringing some false MLC and false statement, false witnesses, but maybe she didn't find anyone to give false statement. So after harassing for 2 months, she withdrew herself, right?
yes, correct. So and I had some
Okay.
couple of counter cases also, and I know she is working, as she is
Hmm.
well educated, and we don't have child also. So fighting along for getting nothing is a bad decision, she thought, and that's why she withdrawn it.
Okay. Okay. It was in police station only, or it went to the court.
No, it went to the court, and there only she withdrawn it using PP under
Okay.
section
So what
321.
reason she gave?
She did not give any reason, but just did not give me any sympathy, like why she filed the 498A and she is withdrawing in 2 months only. And for that reason, I got remanded. My career got spoiled. Just did not ask anything, and judge was giving sympathy to my wife, like why is there any coercion that
Okay.
you are
Judge
going to
also not
withdraw in the cases?
take. Yeah, that's what judges also doing. This is the second line of defense. Judge should have checked on such false cases and misuse of law, but judges are also not checking. Even women are when their motive is fulfilled, or whatever demands are met, they allow them to withdraw. And judges are not filing
Yeah,
340 perjury for giving false statement or false affidavit or anything. This is the another abuse of law, and all these police judges are supporting legal terrorism. Anyway, with this case, your reputation and you are harassed and you are depressed. You filed a divorce case on that.
yeah, I was completely depressed, and I went to the depression. My colleagues and my friend, they supported me, and the FIR
Hmm.
copy that was sent to my HR head. So they said like, why this is happening? We hired you to work in a reputed organization, so why it happened? Then police got me
Hmm.
arrested from my office premises, so my reputation went down. So I was not able to go to office for 2 months. So that was a very
Okay.
painful period for me. And my parents also, they are
Yes.
aged, and they are BP and sugar patients. So my father got heart attack and my mother, she got hospitalized. That was a painful
Okay.
period. If I
All this
remember, then my
harassment
head
and
feels something.
abuse, everything is going on in men's life, but no one care. Our Indian government is never reimburse or uh, whatever reputation is gone, they cannot bring it back. Men are because of these false cases, men are losing reputation in society. But our government is turning blind eye on all these cases because out of 100 cases, even NCRB is saying almost 80-85% are settled out of court once money paid. How much did she file maintenance after this?
No, she did not file maintenance, and I had a clear discussion when she withdrew on the 498 that if the litigation continues, then it will be a long fight. so we'll be getting nothing. And you already withdrawn the case, and I got the acquittal. So on that ground, I can file divorce, and I can get the divorce. So for that
How did you
reason,
articulate
we had a
in your
clear
case?
understanding.
Because she withdraws that. Yeah. So you
Yeah,
settled
yeah, she withdrawn, and I got.
to not to claim maintenance.
Yeah, please. Yeah, if
Okay.
she is trying for the maintenance
Uh,
also, she will be
okay.
getting very
One more
less,
last.
around
Yeah.
two to 3,000 or 5,000.
Hmm. Yeah. Because she was working.
So yeah, she is also working and she is
Hello.
getting a very good amount of money.
Okay.
Hello.
Okay. Good. That's why because if she is working, working woman is not eligible. Still, many are claiming and they are getting also without checking. Judges are
Yes.
not checking women are working or she has assets or she has income. Even you are producing her IT or income tax return or assets details, house, whatever, money, bank balance, they'll just blindly order the maintenance just because she's a woman and she is filing some false case to show that there is a domestic violence or dowry demand or whatever, beating or other cases, just to show and claim maintenance. Anyway, how are you feeling once comes out of this wrong marriage?
Yeah, this August 2020 only I got the divorce decree. So I'm not feeling good. So I'm feeling very sad for those women who doesn't understand the value of love and affection and gets trapped by the biased law and destroys their humanity and life. And in the end, they gains a little money and no trust or no true love they are getting. But the system is earning so much money because of this police girl. So I pray to God that they can save a family and they can build a happy family and
Okay,
uh, uh, they can be eligible for someone's true love and affection, so they can build a happy family. I request them not to use this
okay,
biased law.
okay, 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 okay. And one more last question. You have any message to our legal system and our government of India?
Um, Mrs. If they are making, they should consider men and women as equal because human rights is like both all the humans are same. So why, according to men, there are very less laws and there is biased law for women only for women protection. There should be justice for both. So why it is one-sided and they are earning because of this biased law?
Yes,
So if they can make everyone equal, then it will be a better
yes.
India.
Okay, yes. I think someone from government of India or NCW, WCD is listening to us. This is the message. Women are misusing just to claim money and maintenance, nothing else. Most of the domestic violence 498 are false. This is for your information. Thank you, Saga, for being with us. Thank you very much. Uh,
Yeah,
now
thank
we
you.
are finished with Men Ki Baat. Please join us next week with the new guest in our Men Ki Baat. Anyone want to join us? Please message us. Please visit mynation.net and notify us the contact numbers. Uh, Thank you, everyone. Now, Dr. Vikas Singh will continue with next. Thank you, everyone.
Thank you, Sagar ji. Thank you, Rodolph ji. So our today topic is about RTI, Right to Information Act. Mr. Raghav will give the information. Will present about the Right of Information Act. Mr. Raghav is a software engineer and a law student, and he is also member of MyNation Foundation. Mr. Raghav is fighting against the gender biased laws and system. In this fight, he took the study of law. Today, he is going to share his experience about Right to Information Act. So without any delay, I will like to welcome Mr. Raghav to start his presentation. Thank you.
Oh, uh, thank you, MyNation. Just to check, is my screen visible and I'm audible? Hello? Hello.
Yeah, your voice is audible,
Yes, you are
but
audible.
you're
Yeah, I just wanted a confirmation. Yeah, yeah.
yes. Okay.
Uh, yes.
Yes, yes,
Uh,
yeah. Go ahead.
uh, Thank you, everyone. So we have heard Sagar, where he has spoken about the impact which has caused to him due to the false 498 cases and the other such things. We are actually in a situation because we deserve it, because we have been tolerating it for so long. Now we have a tool, RTI, Right to Information, where each individual can actually ask the government as well as the people in power anything which they are taking any decision. Is it really useful to a society? Whether they are upholding the democratic norms which our constitution has envisioned. So I'm going forward. So what we cover in this particular session is very brief. RTI, what and why? What is RTI supposed to do? Why? What it is doing? There is a story of Mazdoor Kisan Sangathan, a very small organization which was the cause of origin of RTI Act to begin with. What is the procedure to file an RTI? What is the fee required? What is the timeline within which you get a reply? What is the appeal procedure? What will you do in case of rejection? What are the grounds of rejection? And is there any deterrent or penalty which can be imposed on the public information officer in case your information is not provided? Then I would actually give you a sample RT application. It's a very simple application, uh, following which we'll understand how can we make a first appeal to the State Information Commissioner, then appeal to the Central Information Commissioner, and abuse of RTI. So RTI has been one of the foremost act which has been used and abused. Used, we have found many 2G scams, the coal scam, the CWG scam. Many have been uncovered using the RTI. Even recent, the Rafale details were actually uncovered through RTI, and these are admissible as evidences in a criminal and civil cases. So we will also talk about the evidentiary value of an RTI reply. And one important thing when you're using RTI is how to effectively make an application. Most of the time, it is seen that your RTI is actually disposed of under various silly reasons. How do we overcome it? How can we make sure that we get our information which we want? And the new changes to RTI, we'll speak on those the changes as well. So coming back, what is RTI? First of all, the Right to Information Act is a tactical regime. It's the first time in this country that through a statutory law, we are able to get access to the information which is with the public authorities. They are just custodians. They have this information. They have not been giving us, and this is a practical procedure through which you can get the information. So the whole objective of RTI Act is to promote transparency and accountability. Today, there is a lot of question on accountability of the police, accountability of the judiciary, accountability of the government, the way they make the acts, the way they promulgate ordinances, the way police are arresting people without any due process. So these all can be actually questioned or asked through RTI. And the most important thing about RTI is time-bound delivery of information. There is a 30-day limit within which you have to provide the information. If the information is not provided, it is considered as denial of information. See, such a beautiful thing. With a small time bound, you have made the onus of providing the information on the public authority. Now you have shifted the total burden of him onto the public authority. Till yesterday, you were at the mercy of the public authority to get any information. Let it be an FIR, let it be a complaint, let it be the status of your ration card or birth certificate or even your marriage certificate. All were at the mercy of the public authorities. Now, RTI provides you an opportunity to question it or to ask why there is a delay or how many more days it will take. So RTI also balances the rights of an individual versus the public interest. So it has generally in RTI there is a exemption clause 8 and 9. 8 explains there are 10 clauses. There is a where the information can be prohibited from being provided to a particular applicant. Especially there is a clause called 81J where the privacy of a person is one of the grounds which is used to deny information. But in a democratic country, everything is limited. So you have to follow a due process. There is a procedure established by law. If that is if that is followed properly, you can still have access to information. So it's a very balancing act. It doesn't actually encroach upon to the privacy of an individual until unless it is affecting the public interest. Okay, that's a very important thing. But it has been routinely used to deny information. RTI, so there's a famous saying. So RTI is a rupees 10 public interest litigation. So each one of you can file RTI. No degree is required. Nothing is required. You just being a person under Section 6 of RTI Act can file an RTI application with any public authority. Story of MKSS, Mazdoor, Kisan, Shakti, Sangathan. In 1996, this is a very small village in Rajasthan, namely Bhim Tehsil, a very backward region. The people there were they were actually working. They were working in construction of dams, they were of the roads, but their names were not available in the muster rolls. Because of this, they were not paid at all. This small backward region, people organized together and they actually literally made the DM, the district magistrate, to put their records on the public domain. They made him write it on the walls. This was actually useful in exposing the gross misappropriation of funds. And this grassroots movement spread across Rajasthan as well as other states. In one instance, the people's anger was such a great extent that the electricity engineer who took a bribe money had to give back his 15,000 immediately. So it was more effective than going to a court. If you have to go to court, you file a civil or a criminal case like corruption. It will take its own time. 15,000, it will take 15 years. But with RTA, they were able to get immediate relief. We are putting a pressure on the authorities to provide the information in a time-bound manner. Later, National Campaign for People's Right to Information spearheaded the enactment of RTI Act, which is in the present form. So this is a small story. Why I have brought this story is when a small backward region in Rajasthan is able to bring out such a beautiful act, we men who are actually facing this kind of onslaught through biased laws, we can do much better. We are educated, we have enough resources. We just need to organize ourselves. We are not trying to say that women are bad. We are just trying to say that in a guise to protect and promote women, you are actually crubbing or reducing a man to a very slavish role. That is not acceptable. It's a political game which is being played out. So information is power. You have information, you can do many things. You can question people. So, okay, now let's understand what exactly RTI is. What documents can you obtain? If you see the RTI section 2F, where there is called something called information. So it clearly says that any material in any form, it could be records, documents, emails, opinions, advisors, log books, even physical samples, electronic records, anything which the public authority has in its custody. So and such things are any public document. So a public document is defined in Section 74 of Indian Evidence Act, where it is a document which a public authority has. As well as in criminal cases, generally the investigation process, the station diaries, the police registers, log books, the forensic lab reports, a letter to police, any complaint or non-cognizable complaint, the charge sheet, FIR, MLC reports, many of them. And in civil cases, you could get your employee provident fund record, sale leads, your tax evasion petition status, birth and death records, attendance, leave of public servants, even judicial proceedings, especially the administrative part of the judicial proceedings are accessible. But there is a clause. Recently, the Supreme Court has come up saying that when there are rules of High Court or Supreme Court, they have to be given priority over the RTI rules, not the RTI Act rules. So here, but this is a very specific clause. I brought this up because many people want to get access of the certified copies. You can get it through a third-party application in the court. That is possible. But if you are the party to that case, still RTI is applicable. That question is still not answered by any Supreme Court or High Court. So it is left to the interpretation of the individual. This is one of the important thing I just want to bring out. So spouse. So in matrimonial cases, generally this is very important. So the medical records of your spouse and the employee provident fund details, ITR details. So ITR details are not presently allowed to be accessible. But if your spouse is a government employee, then under suo motu declaration of section 4, you could get her or his salary details. Or under section 4, there are 17 areas like the working of the organization, the administrative roles, the roles and responsibilities, the salary structure, leaves. There are 17 such areas which can be covered. The common case laws are provided in the CIC site. This is a very good link where you'll find many relevant citations which can help you in your RTI application. So what is the procedure? So this is a very simple procedure. You just need to have these things. First, you just need to write on a piece of paper or electronically in English or any of the 22 official languages of the but in your case, let us say you are in Delhi, you can use Hindi. If you are in Telangana, you can use Telugu. Whatever is the official language of that area where the PIO is residing. PIO is the Public Information Officer. And always have a point-wise, specific, particular information you want to speak. Information is defined in section 2F. We will understand what kind of information you will get later in the part, but very point-wise, you just ask. You can ask on which day this particular FIR was registered. Provide the FIR, so-and-so FIR. That is one. That's a document you're asking. So it has to be point wise, and no reason for seeking information is required. So there is no reason you need to provide when you're trying to ask any information from the public authority. That is why we call it as a it has actually increased its spread. There is no locus standi. Anyone can find an RTA for information of anything else. So that gives you a immunity or anonymity or power actually. And you just need to pay rupees 10, only rupees 10 for application. Okay. And address to communicate. This is very important. So you need not give your father's name, mother's name, or any other details. You just need to say, I am so-and-so, residing at so-and-so, PIN code number. If you want, you can give phone number, that is optional, but the address of correspondence is important. Section 6 and 7, under these sections, you need to put your, so in the subject, when you are preparing a letter of RTI, the section 6 and 7 will be useful for you. Section 6 deals with any information you want to access from the public authority. And section 7 is about where you want information in priority, that is within 48 hours, where your life and liberty of a person is affected if you don't get such information. So we'll speak about that down the line. So RTI simplicity, its power. Simplicity is its power. You just need to just write what you want, just pay rupees 10, no reason need to be provided, just address it to the proper public authority. That's all, nothing more. It's like writing a letter to your school principal, or in your exam when you were any student, even a small child who is able to read and write can file an RTA. That is the beauty of RTA. It is very simple and easy. Fee. Let's come to fee. So the mode of fee, as we already told, rupees 10 is the application fee. But the PIOs have been very smart in trying to not provide you information in the guise of saying that the mode of payment is not appropriate. So these are the mode of payments as per the RTI rules 2012, section 3: cash, demand draft, Indian postal order, court fee stamp, bank transfer. Again, it depends on the public authority. So I found court fee stamp as the most effective if it is within your state, because it doesn't require any writings. It just requires you to just paste it. That's all. Whereas in cash, you need to take a receipt, you need to go to the office, you have to show your face, and they will be asking more questions. In case of demand draft, you have to go to bank. Indian postal order, again, it has commission. Bank transfer, some take, some don't take. So I found court fee stamp to be most effective way to actually make an RTA application. And so when you're asking for information, so these are the basic things. So per page only rupees 2 for an A4 sheet and rupees 50 for a CD or copy. Remember, whenever they actually ask to provide you information, uh, the additional fee has the additional fee has to be reasonable fee and provide detailed of calculation. How did you come to that fee? So we know that rupees 2 is for one particular A4 size page. So they and you have 10 A4 size page information which you are asking for. So it is 10 into 2, which is 20, but they cannot ask you 50 rupees for it. And if they do that, that is a ground for rejection of your information. And when you can appeal it, you will get your information free of cost from the appellate authority. There are certain cases where certain information, I hear a disturbance. If there is someone, please mute yourself. Yeah, so you cannot deny information for want of fee. So even before you make a request, the PIO, if he wants to provide you information, he can provide a partial information and as well ask, this is an additional fee which you need to provide, then only this other information can be provided. That's how the additional fee mechanism works. And this is one of the most important things. RTI is not just simple, it is friendly also. There is no fee for any person who is below poverty line. How do you show that you are below poverty line? Either a ration card or a BPL certificate can be used and be attached along with your application form. It is very affordable as a child. It's rupees 10 only, man. Let's use it. Now time. So this is one of the key part of any of RTI. So under section 7(1) of the RTI Act, it clearly says that the information has to be disposed or provided as expeditiously as possible in any case within 30 days of receipt of request, not the date of application. Let us say today, on October 1st, I filed application of RTI, and on 4th of October, they have received it. So from 4th of October, within 30 days, they have to dispose it. It is typically seen that the PIO generally waits for the last day or the 29th day, and then he provides the information. Or then he actually tries to give some vague reason for denying information. Remember this is useful because any in RTI it clearly mentions that any method to use to deny information or not providing information within the time limit is also considered as a ground for denial of information. And the matter concerning life and liberty. Life and liberty is like, let us say there is an FIR against you and there is a possibility of arrest. So, and you want to file an anticipatory bail. So while you want to file an anticipatory bail, the required document is FIR. But if you go to the police station directly, and try to ask them. Either they will arrest you immediately, or they may not provide you at all. They will say that we have submitted in the code, go and take it from there. But that is not the case. FIR is a document which is a public document, and it has to be provided. So here the section 7.1 of RTI Act is very helpful. So any person whose life and liberty is under threat. So in case of FIR, you could be arrested, right? So your life, your liberty are threatened. So you can file an RTI under this section, get your FIR, use it as a document to make an anticipatory bail application. And this is one of the importance. Transfer. So every public authority has to help the public information, has to help the applicant. It is not possible for every applicant to know the exact address of the public authority where his information can be available. It is the duty of the public information officer to identify the nearest public authority and transfer your application for the information they are responsible or information which you cannot provide. So that has to be done within 5 days. So remember 30 plus 5 days. In worst case, 35 days, you should be getting your information. And third party. So third party is any party. So there are 3 parties in an application. One is the applicant himself, who is the first party. Second, the public authority, which is the second party. And the third party is, let us say you are asking the information about your spouse. His or her salary details or EPF contributions or leave records or any of those things. Now they become third party. Now the public information officer is duty bound to actually give an opportunity to the third party to make his representation to whether provide the information or not. So that has to be done within 10 days of your application. And coming back, first appeal. So first appeal. So in RTI, we have three things. One is an application. The second stage is a first appeal. The subsequent stage is second appeal. Then you actually file. Second appeal is nothing but filing an application with the State Information Commission. It's an independent body from the public authority. And there is a Central Information Commissioner, which is in Delhi, where you can appeal against the order of State Information Commissioner. The first appeal has to be within the 30 days of reception of your decision by the public authority or expiry of that period. In our case, it's 30 days. So within 60 days of your application, where you had actually initially made an application, you can go for an appeal in case you have not got the proper information or your application was denied or rejected. We have so many clauses, we'll deal with them in subsequent slides. And such application has to be disposed within 45 days again. Remember that. The first appellate authority is generally the superior authority in the same office where you have initially put the application. Second appeal, it has to be within 90 days of your first appeal. Once you have made a first appeal, you got a decision, and before expiry of 90 days, you can make a second appeal, that is to a State Information Commissioner, which is an independent body, which has authority to ask the public authority to which you have actually filed an application to question them or to go into the details why the information was not provided in the form you have asked. But this is the most problematic thing today. There is no time limit for decision for the State Information Commission and Central Information Commission. We'll talk more details in the last slide. So because of this, there is a lot of hogging of your, so it's like 2 years waiting period is put on each and every application. So this time, give info or get penalized. So this is the motto of RTI. If there is any questions, I can take them up. Hello?
Yeah, Raghav, we have some questions. Can we take them up now?
Sure.
Yeah, actually, we have one question from Sriram. He seemed to actually file an RTI asking for 498 cases that have been filed in the last 20 years and their conviction rate for the state of Madhya Pradesh. He actually received the information, like a reply from PIO saying that the information is not maintained in the format desired, so it could not be provided. So in these cases of responses, what can be done further?
So I totally agree with his concern, but we should understand that there is echo. Sorry. Yeah. So first of all, the way you have formatted your RT application is like discouraging the PIO to provide the information. When you ask such a humongous data, already these guys are untrained. They don't have infrastructure. They don't have the attitude of many of the peers is that why should I provide information? Now you have created a situation where your question is asking for, where your query is asking for 20 years of information. It's a huge work for them. Actually, if I were the PIO, I would have told you that it is involving lot of resources to provide such information and cannot be provided. That would be a proper reason to deny your information. Rather, he has told that information is not available. That is totally wrong, because NCRB has the data. Why should not Madhya Pradesh police should not have that? Okay, so you could actually appeal against the particular response to the uh, first appellate authority, asking him to provide the proper details free of cost, because the information he has provided is wrong, incorrect, misleading. Is there
I
any
have another
question?
question, Raghav. Can you actually explain more about life and liberty? Like what all scenarios can be considered under in the previous slide we discussed about this.
Yeah, so life and liberty is one. So there is a chance. Okay, I'll give you an example. The example I've already referred to previously. In case of an arrest, your liberty is curtailed. The police can arrest you at any time in case of a cognizable case, and they can put you behind bars. So what happens is, uh, our criminal trial procedure allows a person to be arrested for the need of investigation, whereas arrest has such a bad social impact on a person. It actually demoralizes a person. His reputation will be under question. So there are your life's total reputation, which is nothing, can be actually curtailed. You can be restricted from movement. So one is FIR. Then, for example, there is something like you have an accident and you want that information immediately, because that can help you. For example, from any government hospital, you have been admitted, uh, and they have a document which can help you provide information that you have been diagnosed with so and so disease or so something like that. That information can help you in protecting yourself. So, like, these are very serious cases where you can use life and liberty. But there is one more clause: don't abuse life and liberty just like that. Life and liberty should be used. Uh, for example, in maintenance cases also we can use. For example, tomorrow there could be an order against you, where there could be a maintenance be granted against you. But if you had your document of your spouse salary earnings, that could actually help you not have such order. That is also one case where you can apply life and liberty. Again, there are sometimes people have been applying life and liberty, but the public authority has been converting them into section 6 and providing the information. So like it again, case to case, it differs.
Thanks, Raghav. Yeah, you can continue further.
I have one question.
Sure, yeah.
Yeah, so life and liberty, okay, 48 hours for first appeal, first RTI. So if I want to go after 48 hours, I want to go for the first appeal. So again, it will be or for 48 hours.
Yes, it again will be going, it will be again 48 hours only if in case the information is not provided. So 48 hours is for the information to be provided. But given you have to add 5 more days for the information to reach you, let us say it won't reach you in the 5 plus 48 hours, 2 days, that is 7 days, you can again appeal to the appellate authority under Section 7. That is totally valid. And there are some cases where people actually have applied to directly the CIC also under life and liberty.
Okay, so in CIC they will give decision within the 5 days. In that case,
They will actually go into your question. They will try to analyze if it's really life and liberty matter, and they have to take it. If they are not going to take it, then the relief you have is to file a writ petition in the High Court or Supreme Court to get certain reliefs. Because under Article 19 and Article 21 fundamental rights, you can always go approach a judiciary to get those rights. But this is a even what you call effective right. Actually, you can immediately get, instead of going to such a tedious way. RTI provides you information at your beck and call. It's easy.
okay, thank you.
Yeah, I'm moving forward. So grounds for appeal. So if the PIO refuses to take your request, he'll say, no, this is not our office where this information can be provided. It is his responsibility to take the application and transfer if it is not related to his. That is his duty. He's paid for it. There is a budget allocated for it. Knowingly giving wrong information. It is many times seen that the PIO actually gives wrong information. Like, let us say this person is working in your office or not, or give me the list of people in your offices, because under Section 4 so moto they have to provide all the information. Actually 70% of the information under RTI should be available by default to each one of us in this country. But we have to actually go to Section 6 and pay rupees 10 and post it and pay rupees 20 more to get this information. So these guys are actually playing a game with us by not following the RTI in its spirit. Destroying information. Many times it has been seen that I'll give you a typical case. There was one of the friend I had. In his there was a case against he had put up a case against few of the other parties where there was a video recording, CCTV footage, which was recorded, and the CD was put with the court. Now, what happened? Because under charge sheet, this information was provided to the court. He filed an RTI with the police station asking for that particular record. Now, what happened? The police said, we don't have such record. We have put it in the court. Now, from the police station, he could not get any of that information. They simply removed that CD. Now, he had to go to the court and file a 91 CRPC against the police to get that record. Because then the police says we never had that record, whereas in their charge sheet they said that record was available. So they actually, some PRs have been very careful not to provide information by destroying information and not responding in time bound manner. The 30-day limit we had, the 45-day limit for the first appellate, and no time bound for the CIC and SIC. And incomplete and misleading information. Most of the time it is seen that they don't give the proper information. You ask something, they give something else, or they give very partial information. So that is also one of the ground for appeal. Malified denial of information. Simply they'll say, mechanically they'll say, it is one of the sections under Section 8. This information cannot be provided to you. It is related to the matter is under investigation, the matter is personal, or the matter is affecting the sovereignty of the state. It is a copyright information. So there are many clauses. We'll go into that slowly. And this is one of the favorites of all for the PIOs. There was one case where the income tax authorities, there was a application. There were two PIOs in two different offices of the income tax department. What they did was they played a game. They looped it. One application was sent to one PIO. He immediately used to transfer it within 5 days to the next PIO. The next PIO after 5 days used to send back it. So in this way, they were actually playing a game. In reality, they were denying information to the applicant. Then the CIC actually said that this amounted to denial of information. And there could be applicability of Section 20 of penalizing that PIO and also taking a disciplinary action against them. So this becomes one more ground for appeal. So you might have received many letters from the PIO saying your application has been transferred to so and so PIO. Please follow up with them. then so they are just wasting the postage money. They are just wasting the Indian postal infrastructure in doing that. Rejecting the application for want of fee. This happened to me actually. So what happened was I filed a RTI. I have put Indian postal order with a receipt and everything. What the public information officer smartly did was he removed my fee receipt totally. And after 30 days also he did not reply. Then I filed an appeal. Then the appellate authority says that you have not filed any fee. Then actually I sent him the receipt and actually sent one of the citations by the CIC where it clearly says that no application can be rejected for a want of fee, because this is a social law similar to how we have the Domestic Violence Act, where they claim that women will be what you call given relief immediately, or under 125 CRPC where the maintenance is a summary judgment. Similarly, RTI is also a social justice law where the information has to be provided even without fee also. You give me a partial information and ask me for additional information. That is a way you can follow. But PIOs generally take this route. They actually remove your payment receipt. So that's why I said court stamp fee is the effective way, because you cannot remove it. Because once you remove it, there is a impression which is made it on the paper and there is no writing involved. Rejecting application on exceeding word limit. This is one of the most flimsiest reason I've seen. Till 2012, there was no limit on words. In 2012, the latest ruling had 500 word limit. And one of my application, the PIO was so ignorant of the rules or laws. He said that you cannot file a application which is more than 500 letters. 500 letters. It was 500 words. He said 500 letters. 500 letters is not even this paragraph. Okay, so and the one RTI 2012 rule clearly says that you cannot just deny the application only for only because it is exceeding the word limit. There has to be other reason. In one of the judgment, the Supreme Court the Supreme Court clearly mentioned that you have to give a sufficient reason for denial of information, not just saying that okay, this is coming under this particular clause of 8 and 9 and so we cannot provide. No, RTA is an act, it's a statutory act, it's a right you are giving to a person. You cannot just deny information based on it is coming by classifying it as some section under some section in RTA Act. You have to give a proper reason. So the relief you have is these are the grounds for appeals. Again, even when sometimes what happens is the other reliefs you have is you can file a writ petition with the High Court under 226 of the Constitution. Similarly, with the Supreme Court at any stage of the RTA. So these are the methods which the PIO will use to deny, delay, and discourage filing of RTIs. So let's come to the actual rejection clauses. So Section 8 has 10 specific clauses, only 10 clauses, beyond which information has to be provided. And there is one more section under Schedule 12 where public authorities are listed from which you cannot get information, like the atomic research or a raw agency, which are concerning the security and state of the country. But again, they also, the information you can get in terms of corruption, those kind of information still you can get from those exempted authorities. So let's come to what exactly are those clauses. So any information which is affecting the sovereignty and integrity of India, any information which is explicitly forbidden by the court, which will amount to contempt of court. For example, if there is a POSCO case, you cannot reveal the names of the children. That is one of the court's order. Breach of privileges of parliament. Let us say the parliament says this particular document should not be in the public domain because it's still not decided. We are still discussing. So that is one of the privilege parliament has. Parliament has more privileges than an ordinary citizen. They can actually shout, insult each other in the parliament, but outside parliament, no, they have to maintain the decorum. Intellectual property rights, anything which will be negative to the foreign government cabinet papers before any decision is taken. Once the decision is taken, that cabinet paper is again available to everyone as a person. So these are the next, the clause B. These are the general, these are the actual clauses within 8 which are used to actually deny information. Fiduciary relationship. Fiduciary relationship means you are holding in the capacity of a trust, like teacher student. Teacher has information about the students marks. School has the information about the teacher's salary. Those are in the guise of a trust. So fiduciary and endangering that is one of the clause which generally has been used to deny information. When you file an FIR, you want to get the information about FIR. It clearly says that if you know the FIR, someone's life is under danger, so we won't provide you. That is not the way. Impeding the process of investigation. This is again the very common 8H, which is very commonly used. But the Supreme Court has said that at what stage of investigation are you? You have to provide that information. You have to at least give summary of information. You cannot just say that in a mechanical manner, no, investigation is in progress, we cannot provide. Then personal info is one of the things which generally used to deny information, which has no relation to public activity, as it will be unwarrantedly invading the privacy of a person. Under Article 19, there are reasonable restrictions for your fundamental rights. That is where this particular clause is getting its power. But Article 19 also foundation for right to information. So we have already discussed it. There has to be satisfactory reason should be provided for denial of information. Bhagat Singh versus CIC, and this is one of the pocket pistols which every PIO will use to deny information. Girish Ramchandran. So in this, the assets, the complaints, the disciplinary actions against the public authority are private information was declared by a division bench of Bombay High Court. And this has been used by the PIOs across India to deny information of any public authority. And there was an SLP in the High Court, sorry, in the Supreme Court under Article 136. SLP is like a special leave petition where you are invoking the discretion of court to take the appeal, but it was just dismissed. There was no judgment. So there was no law put under Article 142 and 141 of the Constitution. So it is not a proper precedent. Still, the PIOs are using this to actually demolish the access to information. So whenever you find this Girish Ramchandran, just say that this is not applicable for your case and file an appeal immediately. The key rule of RTI is any information which cannot be denied to Parliament shall not be denied to any person. So you are as powerful as a Parliament in terms of getting the information, not privileges. In terms, whatever Parliament can access, you can also access. Any person in India can access. So this is the real participatory democracy. You as an individual can participate, you can question, you can ask information, you can make everyone accountable. Every public authority is accountable to you. This is the real democracy. Penalty. Section 20 describes about the penalty which for the PIO who fails to provide information. So now it is 15 years of RTI. Till now, the penalties have been very minimal. Only in extreme cases, only in very high-profile cases, penalty have been levied. Now the trend is changing. The applicant has to ask for penalty. Even the CIC and SIC and even the High Courts, Madras High Court has recently told that if a PIO is not doing his job, he has to be shown the door. Let's start it. So it is maximum 250 per day to maximum 25,000 from the salary of the public information officer. Remember this, not from the government, from the public information officer. You are putting a burden on the information officer to provide the information because he's an independent authority. Though he has a job along with being a public information authority, but he is an independent authority in that organization. But because he is under the hierarchy of the organization, he is always under the pressure to toe the line of the organization. And it includes disciplinary proceeding, disciplinary action. But it's again, we have to give him a fair chance. There is an opportunity given to him to explain why he did not provide the information. We have spoken about the Madras High Court. Right now, this is the need of the hour. We always have to put a clause of Section 20 so that the appellate authority, the CIC, the SIC understand how serious a person is for the access of information. This is a sample RTI application. It has very few details. You just provide the date, place. You always address to the public information officer. You don't provide the name of the public information officer, address of the public authority, and subject is request of information under section 6 or 7. We have already spoken on. I so and so residing at so and so. Kindly provide me point-wise information 1 and 2, and provide. You have to pay the fee. Fee is important, and the public information officer is duty bound to provide you information in the format you want. That is one of the clause. But in case he is not able to provide, then he can provide in any other format which he can do that. There is a discretion allowed to him. And he has to transfer to the nearest public authority in case the information is not available with him. So this is a sample RTI. Is there any question I need to pause on?
Yes, Raghav, we are actually having one question from Tarun. He is asking for who could be the first appellant authority in protection officer office. So seems like most of them are having concerns about identifying exactly who could be the first appellant authority and who could be the second appellant authority. So if you can actually share details where to find for different departments, mostly involving the gender-biased issues.
Okay, so for example, if it is a CAW cell or if it's a police station, wherever you have been asked to come, there you will have a board which will say, this is the public information officer, so and so is the address. That is the first place you need to go. Next, you go onto the internet, whatever the public authority is there, open their website. There you will have a specific RTI section on that. If they don't have, that is a violation of RTI Act under section 4. Under section 4, because within 100 days of the implementation of RTI Act, you have to make sure that most of your documents are cataloged, indexed, and provided in your website so that they are diversely available. So go to their website, search for their address. Again, when you are addressing, you just need to know the address. You don't need to know the information about the officer's name. Just write the public information officer so and so address. And there is a clause of section 6.3, use it always, where you are requesting the public information officer, in case the information is not available with you, kindly transfer it. Don't reject it, kindly transfer it. If he still rejects, then again file a application with the first appellate authority saying that the PIO has not properly understood the RTI Act and mechanically disposed your application in spite of the fact that you have asked him to forward it to the proper public authority. That is his duty. And also the other relief you have is you can actually raise a complaint with the SIC or CIC under section 18, where you are actually complaining against the way the RTA applications are disposed. So first thing is, whenever you go to a place, see for the RTI board. It will be generally in black board with the white letters. Go to the website. The appellate authority is generally in the same office. It is in hierarchy, so every public authority will have the first appellate authority and the list of PIOs, public information officers. They should always have it. In case they don't have it, they're violating the Right to Information Act. In that case, you can directly approach to the State Information Commissioner, writing an application to them, asking them to provide that information to you. That is there.
Raghav, can I add one more line?
Sure, sir, definitely.
Okay, when you're filing RTI first time, if you are not aware, if you want to know first or second appellate authority, you can put that question also as per section 7, 8 by 3 and section 7 of 3 and 0.2. You can request PIO to inform who a particular first or second appellate Sorry.
Yes, sir.
Reply.
Yes, sir. So one thing, as sir said, whenever the appellate, so the first authority uh, provides you information or declines your information, he has to give the address of your appellate authority. He has to tell you this is the appellate authority to whom you have to apply for appeal. He has to give you the address. That is also there. Uh, so first thing is you first try to find the address, then you can get the subsequent address. It's like fish hook. You throw a fish, you'll get answer. You again throw a bigger fish and get the answer. That's how you do. Or we always have. You can ask in our MyNation group. The appellate authorities will be able to direct you to the proper address.
There are samples of RTI on MyNation. You can browse for first or second appeal, all in details. What clause you can add, what sections you can refer, everything is there.
Yes. So within MyNation website, under the RTI section, you can just search for RTI. You'll find a lot of samples, which section, for which authority, under what section, and many samples are available for FIR, for charge sheet. Many samples are available. Please make use of them. Those are already pre-made and have been effectively used, and they have been working. Yeah. Can I move forward? Okay, I'll be moving forward. Uh, so when you appeal is like when that information is denied or information is not provided or misleading information is provided or information is modified, denied, or information is incomplete, then you can make an appeal under section 19. So the subject should be appeal under section 19. Uh, you have again samples for this on the MyNation website. Address it as first appellate authority. You need not provide the exact name of the person. Provide the application, the original application, the decision or the reason for appeal, and you need not pay any fees here. Only for the first application you need to pay the fees, not for the subsequent appeals. For CIC, SIC, address it to the Information Commissioner. These addresses are easily accessible and available on any of your CIC, SIC websites, or you can go to CIC where you have list of uh, addresses of all the state information commissioners. You can go and search for it. Here, the format is provide the application and its decision, the first appeal and its decision, and you have to put an index so that it is easy for you and the information commissioner to decide your matter quickly. But I need to tell you, first appellate is generally a time hogger. It's just extending the time which you actually have to get information. Uh, Instead of getting 30 days, you'll get after 120 days. It takes 45 minutes, 45 days more in between. So actually the first appellate authority's responsibility is to filter down as many requests as possible to the state information commissioner. But it is not being happening because of there's a huge uh, backlog with the State Information Commission, which is taking 2 years. And right now in Telangana State Information Commission, in spite of they having 5 information commissioners, the matters are still 3 years old. 2 years old are still being running. That is the situation where we are with RTA. So try to get as much information as possible for the first from the initial RTA application. I will give you how to do that in the subsequent slides. Abuse of RTA. I just need to cover this also because this is very important, because these are the reasons the public information authorities have been using to deny information. Repetitive RTAs. It has been found that generally people take a sample, they just file an RTA. When they don't get the information, they again file the RTA. They don't even change their name, they don't even change their address. That is not correct. Actually, if you want information properly, please file proper RTI with very specific and relevant data. Don't repeatedly file RTI. In that way, you are abusing the RTI and the real benefit is lost. Similar to how the Domestic Violence Act was supposed to help only women who are in needy, but now it is used by people who are already well off and in every manner good. That's how RTI has been abused by certain section of people, not everyone. Indiscriminate frivolous application. It has been used to actually harass people. Like silly RTAs are found. Like one RTA was like whether I can put a doctor in front of my name. That was one of the RTI application made to the Department of Personnel and Training. So that is the most silly by a PhD student. RT as a tool of harassment. So some people are genuine. Some people are really working hard. I have got many. I have been filing RTA with multiple organizations, and I found one a PIO with the quote. He was so useful, and he was actually trying to help me. And he gave me information which I could not got from the police station also. There are really good what you call public information officers. Let's not make their life miserable. Um, and this is one of the other reason. Like RTI applicants don't go to appeals also. When the first appellate authority asks you to come, they don't appear. When there is a video conferencing put out to you, they don't go. They are just wasting the time of the time. So when you file an application, just because it's 10 rupees, just because it's a one post away, don't waste it. But in our case, it won't happen. But I'm just trying to highlight these issues because these are the grounds which have been used to deny information. The relief for PIO is to actually, if one of us is any government officer, these are the things. I won't go further. This is one of the things which has recently come, disqualifying an RT applicant from filing. So this is the power of a CIC or SIC. They can disqualify you from filing any of those RTIs. Okay. This is one of the key things for any RTI. So most of the time we file RTIs with the banks, with the police stations, with the EPF authorities, with other public authorities. So those are like the documents. So are these documents useful? So why do we do? Why are we filing RTIs in first place to get information? Okay, what will you do with the information? You are trying to put them as a record or document on record with the course, right? So does it have any value? So that's what we need to understand. So if an RTI reply is itself considered as document, let us say you file an RTI with the government organization where your spouse is working, asking that give me the list of name of people who are working, and in that list there is a name of your spouse. That is a primary evidence against that she is working or she or he is working. So that is a primary evidence under Section 61 of Indian Evidence Act. So that's a very strong evidence. Okay. Next, documents obtained under RTI are certified by PIO. When you say certified, it only says that this is a true copy of the document which this public authority has. It doesn't go into the authenticity of the document. It just says you could file a false date of birth certificate to get an employment, but when you get a reply from the public authority about that date of birth certificate, then that is just a true copy of what document it has been produced as part of your onboarding or admission into that office. That's all. It is a secondary evidence. Secondary evidence is admissible under Section 5 to 59 of Indian Evidence Act when you cannot produce the original, or it is destroyed, or it is not in your control. So it is still a secondary evidence. It is still admissible in the court, and you can still make a decision, or the court can take any decision based on that. If any public document, so your date of birth certificate, your marriage certificate, because these are documents which are actually recorded by a public authority, all these public documents are admissible. They don't require any formal proof because it is recorded by public authority where they are following due process or rules. So those are proofs which don't require any further questioning of the public authority. But let us say you do the same thing with the private authority. For example, you are in a school, you are trying to get this your child's attendance, whether he is regularly coming to school or not, whether he is actually skipping the schools or not. So that document is also admissible as an evidence. But in that case, court may actually summon the principal or the teacher to show that this particular document has been prepared as a usual process, as a regular process. where it is presumed that no alteration can be done in the document. That's a presumption, but it can be rebutted again. True copy of the original document. We have discussed this, the true copy of the original document, but it is not the authenticity of the document. And this is one of the important things. A certified copy of a public document is an evidence, because court presumes that any document which is provided by the public authority has a imprint of truth until it is rebutted. So it is always assumed that, let us say you take a complaint copy of an FIR from the police station. It is considered as a certified copy and it is admissible by the court. So that is the evidentiary value of RTA. Now, how to make your RTA effective? This is one thing which I wanted to cover most. First of all, our goal is to get information. We are not trying to target any PIO. Our job is not to make the PIO work. Our job is to get our information. Why I'm trying to say this is there are multiple things you can do to change the system. But right now, let's come out of our shit first. Because let's understand how the PIO life is. First of all, these guys are untrained. They are unstaffed, unbudgeted. They have no motivation. It is seen as a job which no one likes to have. Now, with this mindset, the PIO generally tries to evade his responsibility. He won't be very serious about giving you information. Now, how will you get information from such a guy or person? First, search your suo motu disclosure under section 4. You will get your most of the details here itself. Provide adequate fee. Don't give him a reason to reject your application. Ask simple, specific, time-limited queries. Previously, we found that one of the queries was, I want the last 20 years. Now, this has triggered rejection in the mind of the PIO. You just ask the last 1 year, he would be easily willing to give you. Or give me the information on year 2000, he would be willing to give you. But if you say last 20 years, he would say, no, Bob, it is a lot of time, I cannot give you. So ask very simple, specific, and time-limited queries. Don't ask what, why, when questions. It will be rejected. But if you see the section 2F of the RTA Act, opinions, documents are also considered as the information. But if you ask anything in a why, what format, generally it is seen that they reject it. Instead of why, what, when, reframe your question. Reframe your question. Under what document, or under what law, or under which statute this document can be made available to me? Or just reframe the question so that you still ask the same question, but it will get you the answers. Identify the correct public authority. This was one of the questions we had. So otherwise, it will be very difficult to get proper information. Public interest. So there are certain clauses in section 8F, like the personal information. So you have to provide proper explanation for public interest. How public interest is violated by not providing such information. But again, don't confuse this with section 6.2, where there is no reason to be provided to give for RT application. But here you are trying to ask information which is under exemption list. So for those information which are under exemption list, you have to give proper reason how the public interest is violated by denying such information. Then only you will be getting your information. Understand your PIO. They are untrained, unstaffed. We have low motivation levels. And in case all these fail, you have always section 20, which is a deterrent penal, what you call monetary penalty and disciplinary action. And even Madras High Court has also told that please show doors to those PIOs who are inefficient. Appeal, appeal is important. So sometimes your state information commissioner and the central information commissioner have certain rules. please read them before you actually go for an appeal. They ask you to make certain set of copies. It again depends on each and every specific to those institutions. Give proper reason when appeal is required. Don't just make an appeal because you have a right to appeal. That appeal should be properly reasoned. The new changes to RTI are the following. Under Life and Liberty Matters, the Department of Personnel and Training has ordered all the public authorities to accept RTI through email. This is a very uh, significant move in the Corona time when people are not able to use Indian post and all. There has been a direction given to the public authorities to accept through email. So there was one question where how do you find the exact public authority? You can try sending your application through email. RTI Amendment 2009, that is one of the, I could say, black mark for the implement RTI Act. The information commissioners are now central government employees. Previously, they were independent, thus making them toothless. There is a chronic pendency problem in appointment of information commissioners and state information commissioners. First of all, it has been seen that when the current dispensation was into power, they were not interested to appoint any of those new information commissioners. And the information commissioners need not be any government servant. He can be any person whom, in the eyes of the committee, has a good knowledge about law, society. Those can be people who can be appointed as information commissioners. Only two people have been previously appointed like that. One is Shailesh Gandhi and M. Sridhar. Other than that, most of them were actually government appointees, babus, bureaucrats. There is a plea pending in the Supreme Court to make online portal for each state. We have rtionline.gov.in. That is a very good website. You can create an account on that. You can make a payment through the payment gateway ₹10. Then you could actually see your list of appeals, applications, and from that same window you can file second appeal and the appeal to CIC. It's a very organized site. Similarly, Delhi also has replicated the same RTA online for the Delhi jurisdiction. Similarly, there is one other state they have RTA online. I don't exactly know the name. And Madras High Court has also put one decision where time limits have to be fixed for both SIC and CIC also. Currently, there is no time limit because of which there is a huge pendency. Yeah, this is where I end. Thank you guys. I try to be as brief as possible with general things. So kindly make use of RTI. It is your right. It came after a lot of struggle, and RTI is really helpful to get information about your spouses or any false cases. If there is any question, I can take them up. Hello? Hello? Hello?
Yeah, Raghav.
Yeah,
Actually, we are checking on YouTube. We haven't actually got much of the questions on YouTube, but yeah, our members can actually ask their queries if they have any.
Can you explain more about the fiduciary relationship?
Hello, can you repeat, please?
Can you explain more about the fiduciary relationship? Because this is the most commonly used word by which they can reject the RTI.
Yeah, 1 minute, please. Yeah. So under section 8, 1E, information available to a person in his fiduciary relationship unless the competent authority is satisfied that larger public interest warrants disclosure of such information. So first of all, fiduciary means in the capacity of a trust. So for example, if you are a government employee, the information about your employment, the date you have joined, the number of leaves you have taken, the promotions, the your salary details. These are information very personal to you, but they are held with the government in a trust. So public authority is just holding information which is already It's just holder of information, but it has the authority to actually make it public when it is satisfied that larger public interest warrants disclosure. Okay, for example, it has been seen that one of the RTAs where the woman was asking the ITR details of her husband, it was denied, claiming that it is a personal information cannot be provided. But there is one more section called Section 4, where the salary details of the person are available. And still the person tried to deny that information. But because it's already under Section 4, you can still get it. But whereas the loan information, the investment information of a person cannot be even provided to your spouse. Those are totally personal information. And the fiduciary relationship, in this case, the government, has to actually be satisfied, or the PIO has to be satisfied that there is a huge public interest to provide that information. Let's come to a private case. I gave you an example where take an example of a school. The teacher's information, the student information, the school has that information as a fiduciary, as a trust. Okay, so even there, it can provide that information, but it is not bound to give unless there is a public interest which warrants disclosure. So this is one of the reasons which the PIOs use, say that there is no public interest involved, we won't provide you information. That is a typical denial usage which is used. But you have to provide a proper reason why public interest is involved, which requires this information to be provided. For example, you're getting arrested or you're going to pay a huge amount of maintenance. You cannot allow someone to actually abuse the court's process, right? So that is also public interest. You cannot allow someone to come to court and exploit the court machinery. Otherwise, the total institution of judiciary will be falling as pack of cards. So that is a great public interest there.
Okay, thank you. I have one more question. It's about the data protection, because we are getting new rules about the data protection, and the RTI is about to getting information. So how these two laws are conflicting with each other, means how can we what's the impact of the data protection on the RTI?
First of all, India doesn't have a data protection act, proper data protection act. Second thing, when you file an RTI is also applicable to certain private entities when they are actually within the statutory, when they actually follow statutory law of the state. So this is a very gray area. Right now, you are at a position where you're not getting information from the public authorities, where the data protection is totally different, where your personal data is available to anyone. So we are not yet there. These two have to be understood in a wider way. Right now, I don't have a proper answer for it. This is still in debate, actually.
Okay. So another question I have, suppose if I somebody file an RTI to get my information from an authority, public authority, and I don't want that authority to give that information. Okay, the public authority can contact me. Okay, I want to give this information to that person, but I want to stop that procedure. So how can I file an application or file a complaint? This information should not be given to that person.
So yeah, so there is under section 19(3), the applicant against the person against whom the RTI is filed, or whose information is being requested, whenever he gets such, that's a third-party disclosure under section 11. So he could actually file an appeal with the higher authority, giving reasons such information not be disclosed. That authority always has. He can always appeal to the State Information Commission and this Central Information Commission also. That possibility is there, because we follow, there has to be reasonable ground, or there has to be show cause notice to a guy whose information is being made public. So that is one of the things which is protected under RTI Act. So RTI Act is a very balancing act. It doesn't encroach upon the privacy matters of others without giving them a possible reason. And again, the PIO is given a huge burden to actually understand what public interest it is violating if the information is provided. So it is very strict in that manner. And generally, POs have seen that they don't apply their mind here. They generally see, okay, it is affecting him. Okay, we won't give you information. So that's how I see it today. Uh,
Okay.
Hello.
Yes. Can you explain the fiduciary relationship in relation to the what is called ITR or EPF retail of a person? Suppose I am the husband of the or spouse of that person, and if they asking, they saying it's a fiduciary relationship for ITR or the EPF. So how much
So
it's valid?
right now, EPF information is available because there you are actually uh, the provident fund, the 12.33% of your money which you're putting with your provident fund, that information is accessible because it just says that under fiduciary relationship it is available. But when I say that, okay, I have a maintenance case against me, and it is really important for me to show to the court that this information can be useful in deciding my case, right? So then there is a public interest involved here, because you cannot allow every person who is actually able-bodied and earning can't misuse the law. So this is one of the important things which the fiduciary has to understand and provide the information, because it doesn't say you deny the information, but here there is a large public interest involved, right? So you cannot allow even a man or a woman who wants to exploit the judiciary by denying information. You are actually providing the case number. You are giving the proper reason. You are actually explaining there is a public interest involved here. Then only the PIO has to be satisfied. The PIO need not be satisfied. He can reject it under section 81J, 81E. But again, you have a relief by appeal or SIC or CIC. Uh, Most of the time, the Girish Ramchandran case has been used to deny information. That's how it is right now today.
Okay, I have last question. Okay, suppose if they say it is a third party information, means the information is available but is a third party. So how can I use that in my court case?
Oh, first of all, if they deny the information as third party, that is good, right? Now now that means that there is information about him which is available. You know that it is available. Now you can ask the court to, under, if it's a criminal case under CRPC 91, to bring that document on record by what you call implicating or the authority. Or if it's a civil case under order 15 or something, I don't exactly remember the order, you can again ask for such document from the public authority, because you from by denial you have actually proved that there exists a document. Now the details of the document you don't have. Those details you can still get from the court using the regular procedures of document retrieval process.
Okay, thank you.
Yeah, Raghav, we have a few questions on YouTube channel now. Do you want to take them? Maybe
Yeah,
just 3
definitely.
or 4.
Yeah.
Okay. So we have one question from Sagar. Do we need to produce the certified copies of Form 16 income tax return documents of wife through RTI to court to reduce the maintenance?
I didn't
Uncertified
understand.
copies are also. I think this is more related to, like, if at all, if he has got RTI responses related to income tax returns in Form 16, can he produce them for reducing the maintenance in court?
Yes. So first of all, you have to understand one thing. Any document, even if it is stolen, can be put as part of evidence. You just need to prove to the court that it's an admissible evidence. That's all. So it need not be RTA or something. Any document, even if you go and hack her account, that document is still permissible. Now coming to RTI, because RTI is a certified copy, it just says that there's a true copy of what document the fiduciary has or the public authority has. So it's still accepted by the court.
Okay. Under RTI, can we actually ask for medical record of wife?
Yeah, that is one of the case actually. But there you have to explain to the court or the PIO or the CIC that because you are the spouse of that person, your life and liberty are at stake, because we cannot expect a person to live with someone who is um, doesn't have capacity to be in a proper marriage under Hindu Marriage Act. So there are Section 5, there are clauses within which you can consider a marriage void or make it voidable if a person is having a mental condition which cannot be curable. So that is one of the grounds to through RTI you can get that information, but you have to give strong reasons why you need that medical records. But there has been one case where the medical records are provided to the spouse or the husband in this case.
Yeah, I will like to add in this one. It's very difficult to get some kind of medical records, but some medical records like psychiatric reports you can get from the RTI. And to give it example, there's a famous case of Virappan, and his wife applied for RTI for that MLCs, means his medical records, and court denied that MLCs.
Okay, thanks, Raghav and Vikas. We have one last question. This is from Ravi Kumar. He says he has filed TEP to get IT details of his father-in-law based on case details. He's a businessman, but they have denied to provide as it does not meet public interest. He sent an appeal to next level. They have forwarded to first officer where he got denial, and then again he got a denial. I didn't understand.
Okay, so first of all, there is a judge. There is a Supreme Court judgment where the TEP status, a summary report, has to be provided to the applicant who has made the TEP application. Why? First of all, when you make a tax evasion petition complaint, you are going by the income tax rule where you are asking for a prize money. When you are trying to show someone, when you're trying to help the government identify a person who has been evading tax or not paying tax or being a host of black money. So the applicant has a right to know the status, but not if the penalty has been made or he has been what you call penalized or he has been put in jail. But the summary of what actually happened. Okay, at what stage are you? Has the investigation been complete, or do you require any other documents? So there is a TEP status which you can get. So there is one citation on MyNation. I can provide you in the comment notes later once this webinar gets done.
Okay, thanks, Raghav. Thanks for the wonderful session. We don't have further more questions on YouTube.
Yeah.
Okay.
So
thank you, Raghav. We conclude with this. If anyone has any questions, you can anytime you can approach MyNation. Register with us. It's free. We'll answer your questions. Not only for RTI, any 498 DV, custody, any issue, matrimonial issues, you can approach mynation.net. We'll be there. Thank you. Thank you, Vikas, Dr. Vikas. Thank you, Ramesh. Thank you.
Thank you.
Monty, and thank you, everyone.
Thank you, Rudolph sir. Thank you, Sagar. Thank you, Raghav ji. And thank you, Ramesh ji. Bye.
Okay.